let's get right to the heart of the drama. In a trial full of denials, Trump's lawyer, Todd Blanche, suddenly admitted, yes, Trump approved the payment. The courtroom was stunned. For weeks, Trump's team insisted he knew nothing about the $130,000 paid to Stormy Daniels before the 2016 election. This payment, the prosecution argued, was a calculated move to silence a damaging story and protect Trump's campaign. The defense's narrative, Trump was out of the loop, was tossed aside in a single, shocking moment. Suddenly, the entire case shifted. The defense's foundation crumbled, and the prosecution's argument gained new weight. Why admit this now? Was it a bold strategy or a desperate mistake? The jury, the media, and the nation were left reeling, questioning what this bombshell meant for the verdict and for Trump's political future. This essay unpacks the impact and implications of that stunning reversal. The courtroom buzzed with disbelief. Did Trump's lawyer just hand the prosecution their strongest point? Legal experts debated, was this a clever pivot or a catastrophic error? For weeks, the defense claimed Trump was unaware of the payment. Now they admitted he approved it. The stakes couldn't be higher. Trump faces not just criminal charges, but the risk of derailing his presidential campaign. Was the defense trying to appear honest, hoping to argue Trump's intent wasn't criminal? Or did they simply have no choice given the evidence? The pressure was immense, and this move demanded scrutiny. The trial's outcome could reshape Trump's legacy and the nation's political landscape. We'll explore whether this was a strategic gamble or a fatal misstep. Day 22 began with a media frenzy outside the Manhattan courthouse, reporters, protesters, and cameras everywhere. Inside, tension was thick. The prosecution had finished laying out a story of secret deals and election interference. Key witnesses, Michael Cohen, Stormy Daniels, David Pecker, painted a picture of a coordinated cover-up. Now all eyes turned to the defense. It was their turn to counter the prosecution's narrative. The jury, ordinary citizens with an extraordinary task, listened intently, knowing the trial was reaching its climax. The defense needed to convince them there was another side to the story. Anticipation for the closing arguments was intense, especially after the defense's shocking admission. The stage was set for a dramatic showdown. Trump sat at the defense table, his every move scrutinized by the world. Some days he was animated, others subdued, aware that his fate was in the jury's hands. The prosecution, having built their case, watched the defense's next move with steely focus. Todd Blanche, Trump's lead attorney, faced enormous pressure to dismantle the prosecution's story. Every word mattered. The jury's verdict would hinge on these final arguments. The jurors, silent and attentive, carried the weight of deciding a historic case. They had to sift through weeks of testimony and evidence to reach a unanimous decision. The outcome rested on their shoulders as the world watched. The final day of arguments arrived. Everyone in the courtroom was exhausted but alert. The world watched, knowing the verdict could reshape history and politics. As the defense prepared for closing statements, a tense silence filled the room. The jury leaned in, ready for the last word from Trump's team. The atmosphere was electric. Something big was coming. The defense wasn't just repeating old arguments, they were about to drop a bombshell. Todd Blanche's opening words would shock everyone, changing the course of the trial. This was the moment that would define the case and perhaps Trump's future. The moment arrived. Todd Blanche, shouldering the immense responsibility, the collective gaze of the courtroom converged on him, a silent testament to the tension. Every argument had led to this, the defense's final opportunity to define their client's narrative. The air was thick with the unspoken understanding that the words uttered next could irrevocably alter the trial's trajectory. For weeks, the defense's strategy had seemed to be a carefully constructed fortress of denial. The narrative painted was one of a busy president, far removed from the minutiae. Blanche began his closing argument, his tone initially measured. He spoke of Michael Cohen's credibility, a well-trodden path. There was little to suggest the seismic shift that was imminent. Then, with the suddenness of a theatrical reveal, the script was flipped. Blanche, in a move that would send shockwaves, pivoted. He took a metaphorical sledgehammer to its foundations. His words began to diverge sharply, leading towards an admission that no one had anticipated. Yes, President Trump approved the payment. The words, "Yes, President Trump approved the payment," hung in the air. A moment of stunned silence before the implications began to detonate. Then the frantic scratching of pens as reporters scrambled to capture the sheer audacity of the statement. It was a bombshell, dropped deliberately, leaving everyone to wonder about the strategy behind it. Across the room, the prosecution team must have exchanged glances. Had the defense just conceded a central pillar of their argument? The ground had just shifted, and they knew it. Whatever his visible reaction, the admission directly implicated his knowledge and approval, a fact that would not be lost on the 12 individuals tasked with deciding his guilt or innocence. Now, Blanche was stating unequivocally that Trump had approved it. A breathtaking pivot that left legal observers reeling. Following the initial shockwave of the admission, Todd Blanche immediately began to reframe its significance. The core of this new strategy quickly became apparent. Yes, President Trump approved the payment, but that doesn't make it a crime. This was the key to understanding the defense's gamble. They were attempting to neutralize the confession by immediately contextualizing it, shifting the entire battleground from whether Trump knew about the payment to why the payment was made and whether that purpose constituted a felony. It was a high-risk, high-reward maneuver, aiming to pull the rug out from under the prosecution's feet. The defense's argument sought to portray the payment not as a calculated move to illegally influence an election, but as a personal matter. The aim was to paint Trump not as a political conspirator, but as a man dealing with a private situation, separate from any intent to defraud voters or violate campaign finance laws. This, yes, but strategy was an enormous gamble. At the core of this Manhattan trial, Donald Trump faces 34 felony counts, each tied to the alleged falsification of business records. These records, like invoices and checks, were supposedly mislabeled as legal expenses paid to Michael Cohen. The prosecution argues these weren't genuine legal fees, but reimbursements for the Stormy Daniels payout, designed to keep her quiet before the 2016 election. This mischaracterization was deliberate and deceptive. What elevates these falsifications to felonies in New York is the assertion they were carried out with the intent to commit, aid, or conceal another crime. The prosecution posits this other crime was an effort to unlawfully influence the 2016 election. The $130,000 payment, disguised as legal fees, was an illegal campaign contribution aimed at suppressing a damaging story. Trump's lawyer declared that President Trump approved the payment, narrowing the battlefield to the intent behind the payment and its recording. The defense implicitly says he approved it, but not to commit or conceal an election crime, setting the stage for a fierce battle over motive. Before Todd Blanche's admission, the defense strategy appeared to revolve around creating distance between Donald Trump and the Stormy Daniels payment. They suggested Michael Cohen acted independently, or that Trump was not privy to the specifics. However, the declaration, "Yes, President Trump approved the payment," torpedoes that defense. This shifts the legal calculus. The jury's focus is now on criminal intent. The question becomes, did Trump cause these records to be falsified to cover up an election-related crime, or was there another motivation? The defense's new narrative attempts to frame Trump's approval as driven by purely personal reasons, to shield himself and his family. The challenge for the defense lies in making this argument stick, given the timing. The prosecution will argue Trump's reputation and campaign were linked, making the payment inherently political. For the jury to return a guilty verdict on any of the 34 felony counts of falsifying business records, they must unanimously agree on two fundamental points for each count. Firstly, they must find that Donald Trump indeed caused the business records in question to be falsified. Secondly, they must be convinced beyond a reasonable doubt that he did so with the specific intent to commit or conceal another underlying crime. Without this second element, the felony charge cannot stand. The prosecution will argue the personal reasons narrative is a smokescreen, emphasizing the timing mere days before the election. They contend the primary purpose of silencing Stormy Daniels was to prevent damage to Trump's electoral prospects, making the payment an illegal campaign contribution designed to influence voters. The moment those words left Todd Blanche's lips, you could practically hear the collective gasp. In the courtroom, the reaction was less theatrical, but no less intense. Reporters exchanged wide-eyed glances, their fingers flying across keyboards. Legal analysts leaned forward, absorbing the shockwave. It was a narrative handbrake turn, leaving skid marks all over the previously established defense. Almost immediately, the legal commentariat erupted. Was this a stroke of tactical genius, a desperate blunder, or something in between? Some seasoned defense lawyers suggested it was a bold move to acknowledge an inconvenient truth. Others looked frankly aghast. opining that the defense had just gift-wrapped a key element of the prosecution's case. The airwaves crackled with instant and often contradictory expert analysis. For the prosecution, this admission must have been like watching their opponent suddenly lower their guard. Having his own lawyer flat out state it certainly streamlined one aspect of their argument. Reports indicated the jury was laser-focused as he delivered his bombshell. Some jurors were noted to be taking copious notes. It was a fundamental shift in the defense's narrative framework. No sooner had the words left Blanche's mouth than the news alerts detonated across the digital universe. "Trump lawyer admits client approves Stormy Daniels' payment," screamed the headlines. News websites, television chyrons, and social media feeds instantly lit up. This was red meat for a news cycle ravenous for any dramatic twist. The speed at which the information disseminated was breathtaking. Naturally, the cable news channels went into absolute overdrive. The whiplash for any viewer attempting to channel surf for a consistent narrative must have been considerable. This highlighted the fierce narrative war that instantly ignited. It was about controlling its meaning in the public consciousness. Different media ecosystems immediately began constructing their preferred narratives. Meanwhile, the digital town square of social media erupted like a volcano of hot takes. Lawyers, pseudo-lawyers, comedians, and concerned citizens all weighed in. Hashtags related to the trial spiked, becoming global trending topics. This demonstrated just how profoundly this single courtroom moment had resonated, sparking a global online jury. As the legal and media dust devils began to swirl, political strategists, those ever-watchful soothsayers of electoral fortune, immediately started to wargame the potential fallout. For those aligned with Donald Trump, the challenge was to frame this admission in a way that minimized political damage, perhaps by portraying it as bold transparency, or by quickly pivoting to attack the prosecution's motives as purely political, regardless of what was admitted. The aim would be to reassure the base that this changed nothing fundamental, while trying to neutralize it as an attack point for opponents. On the other side of the political chasm, Democratic operatives and anti-Trump voices likely seized upon the admission as a potent piece of ammunition. Here, they would argue, was confirmation from Trump's own team of his direct involvement in the very actions that formed the basis of the criminal charges. They would look to weave this into their broader narrative about Trump's character and fitness for office, hoping it might resonate with undecided voters or those Republicans growing weary of the constant legal dramas. The soundbite was too good, too clear, to ignore. Beyond the strategists and spin rooms, the admission rippled through the wider public consciousness, becoming an instant topic of conversation, from office break rooms to family dinner tables. For people only passively following the trial, this was a development that cut through the noise. It was simple, direct, and undeniably dramatic. Did it change minds? In a country as polarized as the United States, immediate, large-scale shifts are rare. However, it certainly fueled existing perceptions, providing fresh fodder for debate and reinforcing deeply entrenched views many already held about the defendant. Ultimately, the lawyer's bold declaration, "Yes, President Trump approved the payment," cast a long shadow, raising profound questions that extended far beyond legal arguments or the specific charges. In the court of public opinion, did this moment make Trump seem more accountable or simply more ensnared in his own alleged misdeeds? Did it humanize him by admitting to a personal protective measure, or did it solidify the image of someone willing to bend rules? These were the ponderings that began to circulate, adding yet another layer of complexity to a trial already brimming with it, ensuring its echoes would be felt long after the jury rendered its verdict. Right, so the legal theatrics, the closing arguments, the he didn't tango, all that is now officially over. The spotlight now shifts onto those 12 ordinary New Yorkers who make up the jury. They must retreat from the public gaze, from the relentless media storm, into the deliberation room. Their mission involves sifting through an absolute mountain of evidence, weeks of testimony, to decide if Donald Trump turned creative accounting into a felony 34 times over. Behind those closed doors, this is where the real nitty-gritty happens. New York law demands a unanimous verdict. Every single one of those 12 jurors must agree on each specific charge. Imagine trying to get 12 New Yorkers to agree on the best pizza place, let alone the fate of a former president. They'll pick a foreperson, pore over the judge's instructions, and then meticulously dissect every piece of evidence, knowing their decision will be etched into history books. The menu of possible outcomes is quite varied. They could come back and say, guilty on all 34 counts, sending shockwaves around the world. Or they might deliver a mixed bag, guilty on some, not guilty on others. Then there's the full acquittal, a not guilty across the board, which would see Trump practically levitating with vindication. And there's the possibility of a hung jury, where the 12 just cannot agree, resulting in a mistrial. Should that fateful moment arrive when the jury signals they've reached a verdict, the tension will be thick enough to spread on a bagel. Everyone will scramble back, hearts pounding, as the foreperson stands to deliver the decision, count by agonizing count. Mr. Trump's reaction, whether it's a fist pump, a stoic glare, or something completely unexpected, will be beamed around the globe. If it's a conviction, the judge decides the sentence. If it's an acquittal, expect a victory lap of epic proportions. A hung jury, prepare for more arguments and more headaches. Let's discuss the political earthquake any verdict triggers. This trial has never just been about invoices and ledger entries. A guilty verdict would be unprecedented for a former president and presumptive nominee. It would arm his political adversaries and send the Republican Party into chaos. Conversely, a not guilty verdict will be declared a vindication by Donald Trump. He'll frame it as proof of a politically motivated witch hunt and supercharge his base. Democrats would be left explaining how their case crumbled. A hung jury would just mean more fuel for everyone's fire. The implications for the 2024 election are monumental. The political optics of a candidate with a criminal record are less than ideal. An acquittal could clear a significant burden, making the electoral contest more ferocious. This trial will become a chapter in America's polarized politics. Public trust in the legal system is likely to take another hit, further entrenching partisan divides. The only certainty is more shouting. We stand at a precipice. After weeks of legal arguments, we've circled back to the admission. Todd Blanche uttered those fateful words, yes, President Trump approved the payment. It was a gamble, a strategic pivot. This became a central axis around which the outcome now revolves. This single sentence continues to reverberate. 12 ordinary citizens are tasked with untangling this complex web. Was Todd Blanche's admission a calculated masterstroke or a catastrophic error? Legal scholars will debate this for years. But ultimately, the only opinions that truly matter now belong to those 12 jurors. Regardless of the verdict, this trial has carved its own unique niche in legal and political history. The echo of that one sentence will linger long after the final judgment is rendered.